Good morning, ladies and gentlemen, and welcome to today's presentation, GDPR Deadline Day and Beyond. This is an important topic for discussion for businesses worldwide, as many of us process, store, and transmit EU citizen natural person data quite regularly. As most of us on this session are aware, May 25th, this Friday, is fast approaching, and our panel today will focus on what lies ahead over the next few days for those of us who are preparing or prepared, for those of us who are as yet unprepared, and how you can work towards GDPR compliance efficiently and accurately. During the course of this panel discussion, you will be able to ask questions of us via messaging located to the right of your screen, and we will make every attempt to answer all relevant questions during the course of the next hour, which we will probably save towards the end of the last 10 or 15 minutes. Before we begin the session topics, I'd like to take a moment to introduce myself and the panel. We'll start with Brian. Brian Rutledge is the Principal Security Manager for Spanning Cloud Apps, where he publishes a blog on GDPR compliance. He holds an MBA from the University of Texas at Dallas. He's a CISSP and has been in the IT and security field for 20 plus years. He's also a former submariner serving in the U.S. Navy. Heather Stratford is the founder and CEO of Stronger International, a 12-year-old cybersecurity firm based in Washington State. The Stronger team works around the world to help organizations find better security and compliance solutions, including GDPR. Heather has a degree from Brigham Young University and an MBA from Thunderbird, the Global School of International Management. She speaks nationally at cybersecurity conferences on privacy and security. GDPR is a main speaking topic for Heather as she helps large and small businesses become compliant as part of their security strategy. Heather recently received the prestigious 2018 Women in Business Leadership Award, sponsored by Whitworth University. She's also recently spoken at Create Your Cloud Strategy Conference, National Security Awareness Forum, and a number of other conferences. And final with Cal Poly's Law Enforcement Cybersecurity Conference and Cal Poly Women in Cyber panel, as well as recurring speaker on this BrightTALK platform. As for myself, my name is Kalani Enos. I have been in the IT and IT security realm for going on 20 years now myself. I got my start with the U.S. Department of State, where I worked as a foreign service specialist, as an information management specialist, working at U.S. embassies overseas, as an information security systems manager as well. Left Foreign Service and worked for numerous military intelligence and Department of Homeland Security organizations, and ventured into the private sector in 2012, where I have worked for a number of large companies, prepare for information security, information assurance, and data privacy. So enough of the introductions. I'm going to begin with a number of topics, and Brian, I'm going to let you lead this one off. Why is GDPR important to non-EU-based businesses?
Many businesses don't realize whose data they control or process. A lot of times these guys or these companies, especially in the US, will feel like, well, I'm not dealing with anybody in the EU, I'm not selling anything to them, so why should I care? A lot of times they don't realize that they've got employees or ancillary customers down the line that they're not really paying attention to. So what they really need to be doing is looking at every kind of application that they use, anything that deals with any kind of incoming data where they could possibly be a controller of data, and make sure that they realize how they can deal with incoming data subject requests, or are they actually processing data as a third party for someone else? These are the things that are just really, really hard to understand sometimes for people who aren't really tasked with understanding this regulation a lot of times right now.
We can't hear you.
Thank you. Sorry about that. Okay, that was an excellent, excellent point. Heather, did you want to expand upon what he was sharing with us?
I think the regulation was put into place because they're trying to make companies guard their data and be data stewards, to really look at the stewardship of what they're controlling. We would say the same thing if we translated it to people or translated it to property. We'd say just be stewards of that land, right? Be stewards of the data that you have on citizens. And so what we need to look at it is not, oh, great, another regulation, something new that we have to comply with, but look at what's the underlying message and why it was put into place. And that is, let's take better care of and think about what data we have and why do we have it and do we need it. And if you look at that from that perspective, we can see that it applies to everybody. And we'll probably go into it more about the future, right? And that this is probably not where things will end, but where they're beginning. And if every company looks at it in terms of, I have stewardship over this information and data, and yes, these are guidelines, but they're here for a reason, and they're here to protect both my company and other people.
Again, yes, excellent point, and I wholeheartedly agree. And people look at me funny when I tell them that I'm actually a fan of GDPR and the U.S. Department of Commerce EU Privacy Shield that it's associated with it. Because again, this is an opportunity to take on their motto in the EU of the privacy by design. It's going to be interesting to see, from my perspective, about whether or not how successful this is going to be and how much pushback we're really going to get, especially here in the States, because of the fact that stewardship that you're talking about, does it extend to how much information about us, specifically with regards to a lot of that special information, special category information that you may find in Article 9, which we may talk about later, really does a deep dive into data analytics, predictive profiling, and data mining overall. It's a tremendous business here on the stateside in the United States, and generates a tremendous source of revenue for us. So, but with that said, yes, I'm very much in agreement with you, both actually. So, so that actually kind of segues, into a point that you have. I want to give an example of that, that might not and that is, what do universities in the United States need to comply with GDPR? So, we're going to be talking about business quite a bit, but, Heather, you brought up a pretty interesting point that we needed to consider, and I'll give you the opportunity to talk about that.
Okay. Universities are a very unique area, and they have research, they have medical schools, they have a lot of data on people that they're educating, they have a lot of visiting professors. The company that I work for and run does a lot of work with universities, both within the United States and outside the United States. Mm-hmm. And I've spoken with several of the CIOs, CISOs, and said, what are you doing to prepare? And many of them have an attitude of, well, we'll just wait and see what happens in the courts. I mean, that's literally a quote. We will wait and see what happens in the courts. And as I've talked to them further, they've realized they can't wait and see, because they have a lot of money that runs through universities. I mean, we're talking the endowments, the alumni networks. They have lots of databases. And because of that, universities are very unique. They are not like most companies because they run siloed. The alumni area doesn't necessarily even know what, say, the medical research area is doing, because they're very different, but they're all under the same umbrella. And the data set can be in different areas, but it can also be shared. And so universities have a very unique responsibility moving forward. And to those who said to me, hey, we'll just wait and see, they've also been scrambling at the end to make sure that they know what data they have. Many of them are secure, but it's the compliance side in terms of documenting where things are at and what their policies are for each individual department that is so monumentally large to tackle. There are solutions for that, but what I'm saying is, if you bury your head in the sand and say, oh, this doesn't involve me, then you will be rudely awakened, and you will have all kinds of problems on the regulation side that your university, that your organization really doesn't want to be in, right? Preventative measures are way better than trying to fix things after.
Oh, absolutely. I mean, and that's been kind of like the mantra, we know as cybersecurity professionals that we have followed, that we've kind of been chasing our tail on that one, is that as much as we preach about being proactive versus reactive and preemptive, there's still a lot of foot dragging out there. But there, as you were sharing, that you have CIOs and CISOs and board members of publicly and privately traded companies and private companies as well that are really starting to see the light. And a good bit of this has to do with obviously the amount of money that they can be fined for non-compliance. You brought up a really good point as well about how the overall posture for security has been over the course of the years is that encryption equals security, right? And that's just part of the process. In fact, when there's a little bit of, I would call it vagueness within GDPR that talks about cybersecurity's departments and IT security and information assurance roles with regards to how they're going to address it. I don't mean that it's intentionally vague. They just talk about encryption as being part of the key. But one of the other things that they do definitely talk about is that you must perform a risk assessment and an overall evaluation, which definitely talks about what you were discussing, which is the data discovery and data mapping, and what are your policies, procedures, standards, guidelines, and best practices with regards to each department and how they go about processing and or storing that data. And whether or not because the way that they process or store that data, do they fall under the realm of processor and or controller? Brian, I mean, if you want to take a moment and discuss what the difference is between a processor and controller, and maybe give an example of each, I'll give you the floor.
Sure. Controllers and processors can be similar but different in different ways. So controllers of data are going to be companies or individuals even that bring in, have direct contact with data subjects, and they manage their data. And they can have sub-processors on the back end that process as well. Processors are going to kind of be a middle person in this organization, where you might be a business-to-business solution where you have duties where you're taking something from another company and manipulating that data, either storing it or running it through other applications and utilizing that data. And so you're bound by, in the past, it was more of a controller issue with the previous data privacy legislation in the EU. Now processors are actually being brought in and being responsible for those data subject requests and managing that data as well, and complying with the new GDPR regulation. So that's another thing that I feel like people don't realize, that they might be a processor of data. They feel like, well, I don't actually take that data from another, from an individual, that may not apply to me. But now that is something that does apply to all processors and even their sub-processors as well. So everybody down that chain of custody is part and parcel compliance. What I was also going to go back and touch on what Heather was talking about earlier was, even if you don't have necessarily a process in place and you're having that wait and see kind of attitude, What you should at least be doing is doing some sort of procedural documentation of how you would actually take a data subject request. What you may not even have a technical solution in place, but if you have a procedural solution in place, that would get you past the starting line at least.
Heather, you want to add to that? I mean, I have my thoughts on that as well, but
I think that's great, because Brian really hit the nail on the head, because this whole talk is about what to do and what to do the day after, right? And many people I talk to say, we don't even have anything, we don't know, and they don't know where to begin.
Right.
Brian, brought up the point, start, okay? Start. And if starting means figuring out what to do with a 72-hour response plan, start might mean saying, where is all of our data? And let's map out how somebody could get their data back, right? Let's start mapping out and addressing the issue. The other thing is time stamping it, because they're going to go backwards, and they could go backwards a year or 2 or 3, and say, at what point did you start taking this seriously and start your process to be compliant? Does it mean you're 100% compliant? No, but at what point did you start? And so if you can put a time date on the fact, we put this together, we had this meeting, this is the information that we put together, we started the process, and here's the timestamp. Timestamp your information and when you're starting, so that you can say, look, we were really trying to be on board. We did it maybe not May 25th, but by June 5th, we had a meeting. By June 25th, we had a meeting. Put some time stamps in there so that you can go back if you ever have to and say, look, we were trying to be compliant as early as these dates.
That is a fantastic point. I can't stress that one enough. So yes, date, time stamping what you're doing, and obviously, again, I think you want to talk about how you want to approach this from a project and project management standpoint, so that again, date and time stamp every single step you're taking in that direction is going to do nothing but help you. I just want to add on to that as far as on top of what Brian and Heather discussed is some of the low-hanging fruit that I'm seeing that people are saying, okay, where do I start and what do I do? One of the things that I think or two of the things that I think that you can definitely address pretty quickly is that is that you can adjust fire a little bit on as far as talking about any of the cookies you create. I see a lot in the way of this is left to your own devices, whether you want to do this, seeing floating banners out there that say, okay, on the main page, because you don't want to have people drill down to page 3 or 4, because then that really gets into non-compliance territory. You want to have something on the main page that discusses anything that you've done, what you're doing with cookies and any information you collect, and possibly even just direct it to your existing privacy policies and go from there. The other thing that you definitely want to take into consideration, and again, this is what Brian brought up, is data subject requests. You really need to be on point with that as soon as possible, because you have 30 days outside of the 72-hour reporting for the breaches. You have 30 days to respond to any data subject requests with regards to any EU citizen who's requesting from you any and all information that you may have about them, within reason, of course, and be able to respond to that within 30 days and without undue delay. So you want to be able to date timestamp those as well with regards to any information that you're collecting. So if you're not ready, come May 25th, and I know that a lot of us who are listening in may or may not be ready, or we have different levels of preparedness. You want to at least be able to have a roadmap to where, as Heather was sharing, you can determine where this type of data is stored and how it's processed and who has access to it and why, as well as what you're going to do with the data, right? So there are specific rights that are afforded to EU citizens outside of erasure, rectification, access, and opt-in and opt-out. But this would be, I think, a tremendous learning experience for all of us with regards to data subject requests. And again, guys, you can touch on this and provide your feedback about, these DSRs can really help you find where that data is. It's going to be, I think it's going to be good exercise for your businesses.
I also think that we need to make sure that if we're doing, if we're acting as a processor, sometimes the controller of data, which is your other business to business relationship that you might have, may have some legal language in their DPA or their data protection agreement, or maybe something that you might have in your data protection agreement in that you've contracted with them, that you have to go through them for DSRs or data subject requests. So you want to make sure that you understand that language, and that if a data subject comes directly to you as a processor, you inform that controller as well, because it's, they're controlling that data for the data subject. And so all three parties need to be involved in that transaction.
Absolutely. And the last thing about any data subjects on this particular topic that I want to bring up is that you need to be able to validate the identity of that person. You need to have exercises in place, whether they're going to be existing manual controls that you may have within your company, or possibly reach out to a third-party company that might be able to do that for you. But you need to be able to provide, for example, some secure channels, some secure portals, for example, on being able to request the information from the person persons requesting the data. You don't want to get caught by delivering data subject requests to people who are not who they say that they are. So that is of key importance. And I'm seeing where that's being a miss with a couple of companies. So Heather, Brian, you want to talk on that? Otherwise, I can segue into the DPO conversation.
One thing I would say about that is beware of malicious insiders. So you want to make sure that with that validation, you do a two-person validation with that. Maybe have the DPO of the controlling agent if you're the processor, and an administrator of that controlling agent come together and sign paperwork or acknowledge that this data subject request was actually something that is a valid request. It's really, I agree wholeheartedly that it's hard if you're not directly dealing with the data subject themselves. You need to know who those people are before you make any changes to any kind of critical data.
Absolutely. Okay, and while you brought up the subject of DPO, we'll go ahead and ask this question: what is a DPO, and how do I know if my company needs one? I'll start off by citing paraphrasing what the GDPR states, and that is, your company will be required to maintain internal records and appoint a data protection officer, or DPO, if one of your company's core activities consists of processing operations which require regular and systematic monitoring of data subjects on a large scale, or of special categories of data, or data relating to criminal convictions or offenses, for example. Okay, so that's a mouthful.
I'd also like to jump in and add to that there's sometimes people say, well, my company's not big enough, right? And they've actually put some stipulation in there. So if you have more than 250 employees, which is not very large, then you are large enough. That there are some special cases underneath that 250 mark. But when we were talking about universities, there's no university or community college out there that doesn't have more than 250 student, faculty and staff and employees. So you're talking about a large section of municipalities, universities, private companies. They all hit over that 250 mark.
Yep, I can definitely agree with that and understand what you're sharing, and couldn't agree more. I have run across this question a couple of times, and I encourage both of you to share as well. If your company is a B2B versus B2C, can you make the possible argument that a DPO is not necessary? Yeah. See, I've run across that question a number of times. That argument can be made. I don't agree with it. Most, for example, especially with your medium and large companies that, because you're starting essentially with 250 employees and above, and on, again, as you were talking about, under 250 for special cases, where you're dealing with human resources. Even if you're transferring some of that risk to your payroll and accounting and in HR firms, you're still more than likely processing and or storing and even transmitting personal data of EU citizens if you have a global presence there.
And even so, you don't necessarily have to hire someone internally either. You could also contract that data protection officer role out. You could even share that with multiple companies. I've even heard of contract DPO roles shared between same industry type companies, where that person has EU legal experience or something like that. You don't necessarily have to be a lawyer, but it makes sense to be very well versed on data protection law in the European Union.
I think the important thing is to think about what is a DPO,
right?
What is their role? And their role really is to be independent from the executive staff. And their role really is to be a watchguard of the data. And if there's a breach or if there is an incident that occurs, the DPO is the person who's going to say, here's our process, here's the 72-hour plan, and they're responsible for looking at it from an objective point of view. So a DPO, if you look at it, what is the role? You really want somebody in place. Now, it might not be a full-time job, like Brian is saying. You can outsource it, or it's a piece of somebody's role. You don't have to hire a separate person to be just the DPO. It could end up being part of someone else's responsibility. However, you have to make sure that in that role that they are uniquely set apart. And as I explain it to some executive staffs, it's like an auditor, right? You don't want them internally in the accounting team. They're the auditor. They're the ones making sure that it's being done correctly. And they have to have some safeguards and ability to do that. And so think about what the DPO's responsibilities are, and then you'll better be able to say how your company or organization can handle having that role and who has that role.
Yeah, I was actually going to just, jump on that bandwagon a little bit. You definitely don't want to have people that's implementing, the compliance efforts. They also have to have that enough independence to where they are comfortable enough to be able to execute their auditing role and their objective opinion to the executive staff. They can't be under fire necessarily for doing their job when there's a privacy issue that comes up.
Right.
Oh, yeah, absolutely. So again, touching on that again, on what you're both saying is that you can definitely present the argument as well that in almost all cases over 200, where your businesses are over 250 strong and you have an EU presence or EU citizen data that you're touching, EU citizen data, excuse me, that a DPO, whether part-time, outsourced, or within your own organization, is warranted, correct? Even if you're a B2B versus B2C, business to business versus business to customer. Because I'm
absolutely.
Okay.
No, sorry. I absolutely wholeheartedly agree. He still requires a DPO.
Okay. All right. Good answer. So the next topic we're going to talk about is, how GDPR affects data governance, breach disclosures, which we talked about with 72 hours a moment ago, and the overall data protection. Brian, you were bringing this up. I'm going to give you the floor. Again, we talked about 72 hours already in the 30 days for DSRs, but anything that you want to talk about above that is
controlling organizations have 70 hours to report to the data processing authorities. What I think a lot of people that are in the processing realm may not realize is they're included in that as well. So a lot of times you'll see controlling organizations in B2B style relationships where they'll say, look, if you have a data breach, we need to know in less than 72 hours. So I think we really need to make sure that that 72 hours is for everybody. And if you want to work with those controlling organizations to let them know about, when do you want to report, when you notice it, when you confirm it, what are those deadlines that you need to meet to help that controlling organization meet that 72-hour window to the data processing authority.
Okay. And do you have any recommendation? Oh, sorry, Heather, go ahead.
I was just going to say, and let's be careful when we look at from the time of a breach, because when a breach happens, is not when you identify when it happens. So you can have a breach way back in October, and yet your organization doesn't figure it out until April. And it's from the time you identify that it happened.
Correct.
So many breaches, the average is 260 days that you've been breached and you don't know it. And so what we're saying is from the time it has been identified by anybody in the organization. So that doesn't mean executive staff knows. That means from the time it's time stamped, that 72 hours is very, very tight timeline.
Yep, exactly. And speaking of, again, couldn't agree more. But speaking of tight timelines, I know we touched on this a moment ago, but how important is compliance to the GDPR by May 25th with regards to outside of date stamping and time stamping your plans if you're not yet ready? Heather, I'm gonna leave that one in.
Okay, so how important is it? It's just like saying I'm gonna drive a car, but I haven't gotten my driver's license yet. So you're on the road and at any time you could be pulled over and they're going to say, let's see, you've been driving for how many months without, right? So you're negligent and you're waiting to see how soon and if you get caught. That's not a great preventative strategy for any company. And so my suggestion is you take the regulation at face value and you do what you can to start being compliant, whether it's hiring a DPO, assigning that role, getting your documentation in place. The documentations, it's a bear if you don't have a resource to help put everything together, but there are resources out there. And so my suggestion to people is take it seriously, start someplace, and start documenting what you have in place, and then work on getting more in place. Many companies will not be fully compliant by the regulation, but if you can show you're working towards compliance, they have the ability to be able to make your fines less, even non-existent, because you were in process. If you can't show you were in process and you put your head in the sand, then they can throw the book at you and say, I'm sorry, you were driving without a license and you knew it and you've been doing it a long time. So you're going to get the book thrown at you. So you decide how much risk you want to put in your company and in your organization when you could do simple things to prevent that type of exposure and risk.
And I'll piggyback off of that. One simple thing you can do with this whole data discovery and data mapping exercise is get rid of data that you really don't need. If you don't need it for a specific reason, stop holding on to it. If it doesn't make sense for your application, for any process you do, if you're just pulling that data in because you've always done it that way, get rid of it out of your environment.
Exactly, and that does segue well into talking about what we discussed earlier about documented policies, procedures, standards, guidelines, where take a look and review your existing data retention and and destruction policies. And if you have to adjust FARO in order to meet the GDPR compliance requirements based upon those rules, then definitely do that. Cannot be stressed enough. Agreed.
I like what you said, and I think people need to hear that. We're not just talking about data that might be in electronic format.
Correct.
We're also talking about data that could be in paper. And many companies still have a lot of paper, and they store paper for other types of compliance things. In the United States, there are a lot of hospitals and doctors' offices that store paper specifically for HIPAA requirements and other requirements. So we're not just talking electronic, we're also talking paper storage.
Exactly. And this is why you were talking earlier about knowing which department, with regards to what their processes are and the legal ramifications and the requirements based upon, as I was saying, legal or HIPAA, or even contractual obligations in order to be able to meet the customers or the client's needs. You just have to, as a business, be able to state what those are, and still have a physical destruction or electronic destruction policy and plans in place, as well as a retention for same. Just document it. So that is a big part of meeting GDPR compliance. So I agree with you fully. Now I do want to talk really quick about a couple of departments that whether they're B2B or B2C that I've run across that where they don't necessarily meet the requirements and they don't understand what the GDPR requirements are. Marketing, specifically electronic marketing, can be declared a legitimate interest via GDPR, and there's a lot of pushback from marketing departments worldwide saying, okay, well, GDPR is trying to kill us and how we go about doing business. That's not necessarily the case. As you were talking about earlier, Heather, you were talking about, I am a steward, right? I need to view this from that point of view. And I need to be able to adjust FARO and be able to protect not only my business interests, but that of the EU citizens in question. So we need to, go ahead.
Be clear that the marketing wing is changing. So before I owned Stronger International, I owned a national marketing firm.
Okay.
And I used technology significantly in the marketing company. And make no mistake that the way business has been done, specifically in the United States, in terms of marketing, is changing and has to change. And it's because, in my view, and from where I saw things and how I saw things done in companies, they were not good stewards of the data. And because of that, people go to the fair and they don't even want to write down their personal information and hand it in for a raffle because they don't know how many, 6 to 10 different people are going to end up with their information. People are worried about where that information gets to because we're not good stewards. And we haven't been over the last couple of decades. And because of that, the marketing side of many companies and advertising side is going to change. That is a ramification of the GDPR. And it might not change overnight, but it will change.
Oh, absolutely. This is go ahead, Brian.
Oh, I was to say another thing that's interesting about marketing that I've been hearing a lot about is, we focus on the electronic, media coming in from a marketing perspective. But another thing that you need to kind of start keeping an eye on is what about events that you attend, right? Where you take in business cards or you scan people's badges and get information that way. There's a lot of things out there, a lot of mechanisms out there that we haven't even really thought of, how we take in personal data and store it. I mean, it could be just as simple as having a whole bucket full of business cards. I mean, what do you do with that? it's just really interesting where all that information sits, and it's not just electronic media.
Right, right.
Absolutely. I mean, a big part of that too that we can go into, I won't deep dive into it, is mobile applications, right? And the terms of service and privacy agreements that we all tend to click on and not really read. And looking at the information that can be collected when you're allowing these applications in order to be able to turn on your audio, turn on your video, collect your, some of your texts, your contacts. All of this, from an EU perspective, can be considered private information, and this really needs, this is going to cause, I believe, not a 180-degree turn with regards to the way that I would call it shadow marketing, and with regards to analytics, predictive profiling, and whatnot is occurring. But we definitely have to adjust fire with regards to how those mobile applications are being deployed. So we can talk to that for a moment. Heather, you want to add on to that, or Brian?
I would say that you're going to have to make things a lot simpler. We've seen terms of service that have been 10 pages of legal jargon. We're going to have to revamp those to make them easier to understand. I've seen some apps that are allowing you to disassociate video and text access and calling, call history and stuff like that. Mm-hmm. But I think you're going to have to allow people to actually still use the application in some simplistic form, even if you turn off those tools. I think a lot of applications now that if you start turning those tools off, the application just kind of ceases to work. If people want to have people use their application, they're going to have to allow them to turn some of this stuff off and still have something viable to use.
And a lot of people download these applications because they think that on the front end that they are using something viable. But again, a big part of what goes on in the background is that the data is collected and turned around and sold, in wild frontier land, right? It's not completely lawless, but as you were saying, you have to simplify it. You have to explicitly state what this is being used for. And I think a lot of people are going to be enlightened as to what truly is collected with regards to the information. And I applaud the EU's efforts in being able to rein that part in. So
I kind of wonder if there's going to be more paid applications now, right? Because a lot of times people rely on advertising and marketing and sales of that information to fund certain things within their business and application. I would kind of wonder now if we're going to see a lot more paid applications out there if you want to use something.
Well, we already see that. Pandora, people like that.
Mm-hmm.
You can have a more marketing heavy service, or you can have one that's less. So we already see that stratification within marketing with lots of services that are electronic.
Mm-hmm.
Agreed. So I'm trying to getting close to wrapping it up here, but before we get into the Q&A session, there's been a couple of questions that have been asked of me as of late about what about artificial intelligence, right? Again, we were talking about data mining and predictive profiling. Article 22 talks about, the data subject shall have the right to not be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her, unless specific consent was provided. Again, we just kind of sort of touched on that. But in my opinion, I think that it is a little on the vague side, and what Heather was talking about at the beginning of the conversation about how some of these articles will let you address this, as you will. And there may be more clarification as time goes on, but what is your take on this, Heather, and then Brian?
Well, I'd like to address the idea of, there is some ambiguity, and that ambiguity, I believe, will be cleared up. I believe it will have to be. They're going to have to clarify certain things as things go through either a legal system or people say, well, what does this mean? The second part to that is be clear that the United States and other countries, Canada, Australia, other countries will probably follow suit. And there is talk of that. How soon? What does that look like? How similar will it be? Those are all questions that none of us really know at this point. But be clear that it's on the horizon. And so when we look at artificial intelligence and collecting that information and how that information is put automatically into other things, these are big questions that the world is going to have to decide how much and what they control. Right now, and this is the difference, the EU sees personal data as a right to their citizens and residents. It's their right to control that information. In the United States currently, we don't have that same view, not right now, that it's not our right to own and understand and have that. Those are fundamental differences. And there are arguments on both sides that they will come closer together or that those will be fundamentally still separate. But the companies in the United States, the companies around the world who are collecting data and even putting it into AI things and pushing the envelope on what technology can do will have to be more concerned about the ramifications of personal data, no matter where they come from and where they're manufactured or where the intellectual property is. And so our world is changing as of May 25th. That is a line in the sand, but it will be evolving beyond that. And the US will evolve their own way. And there's a lot of talk of shifting to something more similar to the GDPR.
I also agree with that. I think things will be clarified after May 25th. But one thing I think we can look at from an AI perspective is consent. If your company or your tool or application utilizes artificial intelligence to aggregate data or something like that or process it, having it stated simply in your consent opt-in and opt-out language and make it easy for those data subjects to opt out, I think that would be a great starting point. Everything is going to change after May 25th, and you know the case law is going to drive a lot of this. But I think if you were just upfront and honest with people and give them the ability to pull out of that artificial intelligence processing, that might be a great start if that's possible. I mean, you have to look at how your application or your process works to see if you can actually do that and give them that granular control.
Yeah, absolutely. I think that one of the things, and this is the last thing I'll talk about before we wrap this up, is that it's going to be really interesting to see how Amazon and Apple and with their Siri product and Microsoft with Cortana, for examples, and Alexa really address this, because they can state that, as part of the making, just for an example, right? And I'm just being a devil's advocate here, not that they are, but in order to make our natural language processing better, we need to collect this information from you, and we need to listen in on what's going on in the background more often than not, in order to be able to better us, so that this particular product that we have can continue to evolve and get better. So again, that's going to be really interesting to see, especially with products such as those. So from a machine learning and an AI perspective. So there are a couple words of wisdom that I want to talk really quick about, and that is just that Brian states that when in doubt, retain legal counsel. In case you have any compliance concerns with GDPR, there are plenty of law firms out there that actually do have a lot of subject matter experts. And when you're trying to get the message out, and I'm speaking to the audience here, do your best to speak in terms of business rather than providing too much in the way of technical jargon, which Brian brings up as a solid point. When you're trying to communicate with the executive team, speaking specifically in terms of 4% or 20 million euro typically does get their attention. With that said, I do want to go into some of the questions and answers, unless you want to add something, Heather or Brian.
I just think it's better late than never.
It is better
start now. Let's go. Get something on paper right now.
Yep. Start. Begin.
Yeah, begin. Yeah, it's no time like the present. Exactly. Right. So Heather, there was a question that was posed. I think you can best answer this one. Does a university qualify as a public authority? I know that.
As a public authority, it depends on the university.
Right.
There are universities that are tightly held and private. There are universities that are public entities, and they're more state-run. So it really depends on the university and how it's set up. Mm-hmm. But be clear that the GDPR does apply to universities in the United States.
Exactly. Okay. So there is, hold on one moment, please. Okay, so this is a question about pseudonymization. We get a few of these. Here's an example. If we send out our invoices by email with subject data in it, and you can't use encryption because our clients are not able to receive encrypted emails, are we protecting enough of the data by using file number and the initials of the data subject? That's actually not quite a clear question, but it's one of those things that I think might be able to play out in court. Did we understand the context of the question, Brian and Heather?
Yeah, I understood the context of the question. Is they're basically talking about replacing key personal information with placeholders that sort of point to the data in question. I think you may not necessarily have to utilize, an encryption, where it's not necessarily just the end-to-end encryption, but it's encrypted in the email or something like that. That's not, I wouldn't say that's necessarily required. What I would say is you need to be able to utilize an encrypted path, right? So if you want to make sure that any kind of browsers you have are set up with HTTPS, they're making encrypted communications that way. You just want to be careful how you're sending that information. Maybe you don't necessarily send the invoice as an attachment. If you can find another way to do that, maybe have some sort of secure portal that they could use or something like that, where that data might reside, that you could have more control over. I think once you start sending emails, you never really know how many hops it has to take and where it gets decrypted and re-encrypted again within the HTTPS connection. So those are the things you just kind of want to be careful of. Maybe just find a different way to do invoicing. Maybe use a third-party solution that is GDPR compliant, instead of sending just a PDF attachment or something like that.
Okay, yeah, that's an excellent answer. Heather, do you want to talk to that? I mean, he brought up what my answer would be, which would be just, if you have the opportunity to just invoke a secure portal, whether that's going to be third party or on your own. That's a really good way to go.
For many companies, it might not work. It's cost prohibitive, or they have an established way of doing things. That way might have to shift, like Brian said. But taking the steps to make a code, going back to universities, they don't use social security numbers anymore to identify students, because they can't, because that's part of FERPA, FERPA, which is the data protection for higher education and K through 12. They can't use that. And so using something else that identifies that account that is not a social security number or specific data is a way around that to help protect that. But the bigger thing about GDPR is it's about protection and incident response and about where it's being held, not necessarily about the interaction of sending out. So there's less clarity on that side so far.
I agree wholeheartedly. Brian, did you want to add to that? I mean,
No, I mean, I think we're going to get more clarification as time goes on, but I totally agree with where it's stored. Where you keep that information is the key liability there. Now, if it's in your email or something like that, you want to make sure that you don't keep those things in unstructured data. Sometimes email is really hard to deal with. I know that email clients have certain tools that you can go in there and do some granular full text search and stuff like that and find that data. But just be careful about that. I'm a big fan of replacing personal information with understandable type pseudonymization techniques. So if you can figure that out, and again, like Heather said, it could be cost prohibitive, but it might actually be something that makes sense because non-compliance is kind of cost prohibitive as well.
Exactly. Yeah. Minimum 2% or 10 million euro, maximum 4%, 20 million euro. That's I think at the end of the day might be a bit more cost prohibitive.
Mm-hmm.
So, one of the things I have noticed is that a number of companies may or may not have something on their shelf that they're not using. Shelfware is a term we use a lot. You might do well as a company to reach out and try to determine whether or not you already have it. And even if you have the subject matter expertise on staff in order to be able to put that application or applications into play. So yes, most definitely. So being able to, outside of pseudonymization, you want to be able to obviously classify the data. We didn't touch on that too terribly much. You want to be able to have a means and methodology for that in place. And you want to be able to determine whether or not, from some type of, this is again one of those cost prohibitive things, but something that I believe is necessary, is to have some sort of DLP, data loss, data leakage protection in place in order to be able to help you, determine what sensitive data might be inbound and or outbound, right? Especially from an outbound perspective. There's Brian, I'll ask you first. Do you have any additional words of wisdom that you'd like to share with the group before we sign off?
No, I like I said before, start now, get going on something, and I really feel like we're going to find out more after the 25th, but that's no reason to wait and see. So I would say hurry up and get something going.
And I'd like to add that there are two specific sides to the GDPR. One is the security side and the technical side of where things are at and the processes in place. The other side is the documentation side, and they're separate and they're different. And you need to start on both sides of the equation. And there are specific people that can help you on those two sides. And not the same person, but sometimes the same person can help, but make sure you do both the security and the documentation side and start now. And there are people out there to help you.
Very well said. There are plenty of people out there to help us, third-party companies and applications, and feel free to reach out to us to us offline. And I have my information available, as does Heather and Brian, on our BrightTALK profiles. And we'll answer any and all questions you may have, time permitting, of course. It's crunch time for all of us, I'm sure. So I want to thank you all today. And if you, again, any questions, feel free to reach out to us offline.
Thank you.